Welcome to Legally Agile with Chris Werner.
Picture this. You arrive to your office on a Tuesday morning and you have an email from a lawyer you've never heard of. Or maybe you walk down to your front of your office to check your mail in the afternoon and there's a certified letter there, again, from a lawyer. Or maybe your business partner calls you and tells you they've been served with something and they're going to send it to you. Either way, what's going on is that someone somewhere has decided they have a problem with you or your company. Whatever the format of this news, the message is clear. Someone has a problem with you or your company legally. No matter how cool you think you are, I can promise you, your heart's going to start to beat a little faster. You're going to start to get upset and you're going to want to fight back and respond immediately. Okay, these are natural instincts, but don't do that. So what I want to do today is tell you exactly what happens when your company or you get served with a demand letter, a lawsuit, or some other notice that you have a dispute facing you. I want you to have a roadmap for how to deal with those first few days after that comes in, and how to make sure that you've given yourself and your company the most options going forward. My name is Chris Werner. I'm the founder of Vidar Law. I have been a commercial litigator and business attorney for more than 20 years, and I have seen these things happen over and over and over again. I want you to be a strategist. I don't want you to respond to these things out of panic, because in my experience, every time someone panics, they end up doing damage to themselves or their company in a way that is completely unnecessary. So let's map out what this looks like. First of all, let's start with what's going on the other side. So you may get notice of this in a couple of different ways. The first way is you get a demand letter. So this is a letter from an attorney saying that someone, their client, has a problem with something that you've done. This may be a former business partner. This may be an employee. This may be a customer. Or someone else, right? They have a problem and you get this letter telling you, you did this, you did that. But a demand letter is just that. It's a letter from an attorney. It's not a legal document, it's a negotiating document. And so I want you to keep in mind when you see this and when you see the language of that letter, which paints you or your company as bad people or bad actors, this is a negotiating document. Okay, so if you can see it with that lens, it will help you to calm down and understand what they're doing. The other way you could find out about a dispute is that you get served with a lawsuit. Now, a lawsuit is somewhat different. This is a formal legal process. Someone has gone to court and filed a suit against your company. The difference here between a demand letter and a lawsuit is a lawsuit will have an actual deadline for responding. Usually that's 21 to 30 days, depending on your jurisdiction, but there will be an actual deadline for responding. But in either case, a demand letter or a lawsuit, what you need to remember is you want to respond to it. You want to treat it as real and you want to respond to it, but you don't want to panic. Also, keep in mind, as I said, this is a negotiating position and the start of the position. For either a demand letter or a lawsuit, remember, the lawyer who wrote that is coming at it from the perspective of the person who is complaining. So they may have gotten an incomplete or an incorrect story about what happened. But that lawyer's job is also to present their client's side in the strongest terms possible. So it is going to read aggressive and like you've done something wrong. But again, it's a negotiating position. And your response needs to meet that where it is. You need to be ready to negotiate with them on that position. So let's talk through some mistakes that people commonly make in those first 72 hours after getting notice of a lawsuit, right? These are things that I've seen repeatedly happen both with my clients and with opposing clients. All right, mistake number one, firing off a quick response. So you get this document in, the demand letter or the complaint, and it's filled with things you think are incorrect, and you say to yourself, I've got to correct the record. I've got to make sure people know that none of this is true. So you send an email back to the other lawyer, or you send a Slack message to your team internally, or you send an email to your board of directors, or you talk to a mutual friend that knows both you and the person that's complaining against you. Or maybe you even pick up the phone and call the person on the other side. So here's the problem with that. Even the most well-meaning response is going to be twisted and used against you, and it's going to be interpreted as an admission. Anything you write, email, letter, Slack message, text message, those are all documents that are going to be discoverable in the litigation. And I have seen those early responses be some of the worst evidence in a file because they were done sort of as a knee-jerk reaction, and they get twisted around and interpreted the wrong way. So this isn't even that you've said something that's incorrect or that you've lied or said something wrong, but I'm going to be honest, lawyers can twist those things, and we do, and it will make you look like you have done something wrong. So resist the urge to immediately fire off a response. Instead, engage your lawyer right away and let your lawyer be part of that process. The second mistake I see happen all the time is a founder or CEO who loops way too many people in. So they get this demand letter and they talk to their executive assistant, and they have a conversation with their business partner, and they talk with their head of marketing, and a few people who are on the board, they have a conversation with them. So now there's way too many people, and all of those people are now going to have discussions. And all of those discussions, whether verbal or through Slack messages or email chains or anything like that, all of that is discoverable information. And you may not know what any of these people are going to be saying. And they may put something in an email that they think is correct, but is wrong. But now that's discoverable, that's evidence, and that is going to be used against you and your company in whatever the dispute is. So the better practice is immediately retaining counsel and making sure that all communications go through your lawyer. Once you've established an attorney-client relationship, those communications are now privileged and they can't be discovered, but you have to have your lawyer in the loop for that. All right, third mistake. With sophisticated business owners, I don't see this quite as much, but I do see it. And sometimes it's on purpose and sometimes it's through inadvertence. But the third mistake is ignoring the complaint. So either ignoring the demand letter or ignoring the complaint. This is done for lots of reasons. Sometimes people think that everything in there is false and it's not worth their time to respond to. Sometimes their heads down on projects and they don't have time to look at it and they set it aside and forget about it. If you do that with a demand letter, like I said, that's not a legal process, so there's no definite consequences, but it does make you look either scared or unorganized. If you do it after a complaint's been filed, you may miss a deadline, and that could result in a court issuing a default judgment against you. So that's a really bad situation. But either way, you don't want to signal to your opponent that you're either scared or disorganized, because they're going to then interpret that and take action. And that may be rushing out to court if there's only been a demand letter, and that may not be what you want. Fourth mistake is picking up the phone and calling the other side directly. So maybe it's a former business partner who you knew very well. Maybe it's a customer in this dispute who's a longtime customer. Or maybe it's a vendor that you really need to resolve the relationship with. And I get it. Maybe you can resolve it with a phone call, but that needs to be coordinated with your attorney. All right. If you do it on your own, even if you're honest and well-meaning, that phone call can be deemed an admission. So let's say you call somebody and you say, "Oh, I'm really sorry this happened," right? they could then turn around and use that in the litigation and say, well, if you didn't think you did anything wrong, you wouldn't have apologized. So obviously your apology meant that you knew you did something wrong. Or you say something, I want to make this right? You may just mean, hey, we've got business and we want to continue doing it, so let's make this right and move on. But you may be inadvertently admitting fault there. And again, it can hurt your case down the line. So even if you think that phone call is going to resolve the problem, make sure you're coordinating that with your attorney. All right. So how do we address these types of situations appropriately? So one of the things that I do, and not all attorneys do this, is when I have those conversations, those early conversations about a dispute, what I'm not talking to my client about is not their legal rights, but what their business needs to get out of this. All right. And there's a number of possibilities that may be what you need for your business. Number one, it may be money, right? This disagreement may be over money that is owed to your business. If that's the case, you will take certain actions to try to move quickly to get that money back. And maybe that is going to a lawsuit very quickly. On the other hand, you may want speed. You may want to get this resolved. So maybe you've got a big funding round, maybe you've got an M&A activity, or maybe you've got a big product launch and you don't want this to get in the way. So you want this resolved fast. So you may just try to negotiate a solution or go to mediation if you can't negotiate directly. It may be a relationship. That may be the most important thing. So maybe this is a key client or a key vendor that's opened this dispute. And really your business need is preserving this relationship. And that may impact how you deal with this dispute. You may need to set a precedent, right? Like, let's say a competitor has come after your company. You may feel that you need to set a precedent because there are other competitors and you want to set the tone of how you're going to respond in these situations. That may mean that you're willing to invest more money into litigation, even if you could get a quick settlement, because setting that precedent and setting that tone is important to how your business is going to operate going forward. Finally, you may just say, hey, we need to be done with this. I don't care what it takes. This needs to end by the end of the week. And again, that's a different strategy for trying to resolve those conflicts. But understanding the business motivation is just as important as understanding where you stand legally. And your business motivation is going to inform the strategy that we take to resolve that dispute. One other thing that you should keep in mind if you're a CEO or a founder is the other side of this dispute may not be your only audience. You may have a board of directors who's paying attention to this. You may have other stockholders who are paying attention to this dispute. Or you may have important customers who are paying attention to this dispute. And you want to consider how each of those possible audiences are going to view the dispute and the way you handle the dispute. Because again, that's going to inform your strategy. And some of those things could be essential to your business going forward. What do you do? What is your 72-hour checklist? Let's kind of run through what you need to make sure you're doing right away. All right. Number one, preserve everything. This is sometimes called a litigation hold. But you will want to do this even if you don't have a formal complaint filed against you. So even if there's a demand letter, or even if you have good reason to believe that you're going to be in a dispute, you want to preserve everything. That means no deleting emails, no cleaning up your files, no deleting Slack threads or putting them into an archive format, no document destruction. And that's even if you routinely do this stuff. So maybe once a week, you routinely go through and clean up your email. You have to stop that. Because even if you're not deleting for the purposes of hiding something, there's a legal term called spoliation, which basically means you've made some evidence unavailable to the other side. And in a court case, the judges are going to take a very negative view, and what they're going to do is give a negative inference to the other in favor of the other side and against you about any documents that are missing. So save everything right away. Number two, you want to lock down your communications. So You don't want to be talking to everybody about this dispute. You want to talk to your lawyer and then let your lawyer decide who else to bring in. So you want to lock those communications down. The third thing you want to do is you want to identify who's going to make decisions for your company about this dispute. Usually it's the CEO or a founder or a co-founder, but it's got to be someone with authority to make decisions and decide how to handle this dispute. You don't want your head of marketing talking to the lawyer on the other side, and you don't want your executive assistant making decisions about whether or not to respond to something. Okay, number 4, and this is very important, you want to engage your attorney early. So you want them in the process as soon as possible. Even if this seems minor, it's worth it to have a 20, 30-minute conversation with an attorney just to confirm that this is minor and to develop at least a sketch game plan for how to deal with it. And finally, you want to map out your timeline. So you should be looking for any deadlines. If the demand letter has a deadline to respond, definitely you want to calendar that and map that out. If you've been sued, you want to map out your response dates so you don't miss that. What you don't want to do is blow through a deadline where there was one there, or not respond in a timely way, because that's going to limit your options down the road. Yes, there are ways to fix that, but it narrows your options. And in those first few days, you want to keep all your options open. So map out your timeline correctly. Business disputes are not something you should be scared of. You never want to react out of panic or fear. You want to react with a strategy and knowing what you're going to do. You also want to understand what you want out of this. Look, I'm not going to lie. These things are stressful situations. And if you're in business for long enough, they are going to happen to your business. But you can deal with them, and you can deal with them well if you have a game plan going in. If you'd like an outline of how to deal with potential disputes, I have a free guide on my website at vidarlaw.com/resources that you can download and keep handy in case a dispute ever comes up. And if you've gotten something in your inbox this week, or you're concerned that a dispute may be coming up, or you've recently had a dispute and you're not sure how you should be dealing with it, you can book a call with me at vidarlaw.com. We can have a quick chat and figure out if you need legal assistance right now, and then what that legal assistance is going to look like. I hope this has been helpful. I hope you're ready to go out there and be successful in any future disputes. And I will see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.